You look at UNCITRAL, and UNCITRAL tells us in Article 10, an arbitrator may be challenged if there are justifiable doubts on their independence or impartiality. The standard we have here is justifiable doubts. You look at the ICC. The ICC tells us you can challenge an arbitrator when there is an alleged lack of impartiality or independence. You see now why the discussion we just had on impartiality and independence is significant. Those are the criteria. But just focus on the adjectives, like you saw justifiable doubts in UNCITRAL. Here you see alleged lack, because these adjectives that are describing impartiality and independence generally give you the threshold that a party who wants to challenge the arbitrator has to meet.
But nevertheless, there was an ICC survey some time ago, and that seemed to be pretty much confirmed by a more recent, but also already 10-year-old CARB survey on costs, which shows that arbitration costs taken as a whole are divided, as I said, between the cost of the proceeding and the parties' costs. And here you can see already that the split is not a 50-50 one, okay? So clearly, the biggest part of costs in arbitration I spent on the second item I showed to you, which are parties' representation and participation. The cost of the proceedings of the arbitral tribunal, the arbitration institution, the secretary, translators, court reporters, that will only make up about 20% of your case. 80% of your costs will be with the parties' representation and participation.
Typically, arbitration is expected to provide a level of convenience that you do not see in litigation. This is most representatively shown in the fact that the legal representation in arbitral proceedings are generally very free, whereas in courts, there are certain requirements of qualification as to who is able to enter the court and plead before the judges. Arbitration does not have that requirement. So a corporation of a certain nationality, for example, a Korean company, would have the freedom of taking their counsel based in Korea and have that counsel represent them in the arbitral proceeding.